able to identify such a person, and I think this is information that the jury, in fact, should have the ability to consider along with everything else in making their determination. This jury deliberated a substantial period of time the first day from noon or 1 o'clock until 9 o'clock in the evening. They deliberated on the 27th for almost the full morning and came back with the decision that they did. I think it is significant evidence as to this case, and a new trial should be granted. If the court wishes an evidentiary hearing in this particular matter, I think that is appropriate under the case law, and if that is the ruling of the court, I think that should be scheduled so that this person could be brought in and examined under oath as to her genuineness, the reasons for not coming forward, and what information that she would have as new evidence. And so I would ask that the court grant a new trial under those arguments.
People's response?
Thank you. Your Honor, I think that first and foremost, because I know that some of this has been addressed by Mr. Schaefer, but I am amazed to hear now how things are kind of played down about this. Approximately 1 week before the trial, Your Honor, Mr. Schaefer's office was looking for information regarding Matthew Ruka. Well, this is the person that becomes a key player in the memorandum of law that he has presented to the court. They seek information, they seek a mugshot of this individual, they look for police records on this individual. That happens 1 week before the trial even starts. The day after the jury comes back with a guilty verdict, suddenly we have a new witness. According to Mr. Schaefer, she's not related. She might not be related. That doesn't mean that she doesn't know this family, merely that she's not related to them. The information that Jeanette Moore brings forward in this case is the same information that the court heard from the Brownells. The scenario is the exact same. They drove by the house on the date of the murder. They saw a vehicle leaving the end of the driveway on that date. It was at a high rate of speed and it almost collided. The information is almost identical. The only difference seems to be the time of day. The jury chose to reject that theory at that time. The information that's being offered at this point is nothing more than cumulative. It's nothing new. There's not going to be any different outcome because that information's already been considered by the jury, whether or not it came from the individual that he's presenting or not. I understand that his argument is as well, yet again we have another time, we must have another vehicle. Apparently everybody from Homer and Teconcha was on Girard Road on February 7th, as best as I can tell. They all seem to see people speeding out of the driveway, but we never hear anything from any neighbor or anybody local ever saying that they see anything suspicious there. The information that's coming from this lady seems suspicious because she waits until after the verdict to come forward. She never reports it to the police. In fact, she seeks out Sue Helm and reports it to Sue Helm. She has yet to ever make a report to the police. She says she's fearful, but she's fearful because she has constant difficulty with some of her neighbors. That's what she signed in her affidavit. That was her basis. But she shares no neighbors in common with the Foleys. She has no relationship to them, and she doesn't know these individuals, so she's really given no reason why she was fearful to come forward. And she's actually given no reason why she's no longer fearful. If, in fact, she believes the killer is still out there, why is she no longer fearful? Tom Foley's been locked up since March 6th, but she hasn't seen fit to come forward before now. If she believes this individual's been wronged, where has she been? She says she can identify the person in the vehicle. It wasn't tentative. The entire memorandum and argument surrounds around Matthew Ruka. She can identify that person in the vehicle. It's Matthew Ruka. Ruka's the person that the defense was seeking the history and the photos on before the trial. She says he looks high. He looks like he did something wrong. But she's a 70-year-old lady. She saw this in a brief moment of passing by, and there's nothing to establish how she gets her expertise on this, how she knows this person is high driving by her, other than the defense knows that Matt Ruka is in jail for a drug charge. Ms. Moore says that she can positively identify Matt Rucka as the person leaving the Foley home. She's shown a picture of Matthew Rucka and identifies him. Their police lineup apparently was one photograph of Matt Rucka. So the defense concludes in his memorandum that Matt Rucka is the murderer. Matt Rucka applied for the charge card, stealing the identity of Tom Foley, and that Matt Rucka sold the card information to somebody in New York. That's essentially what he outlines in his memorandum that's connected to this lady's statements that have come through. But it's not physically possible for that to have happened. Matt Rucka was incarcerated at the time of the murder. He was locked in a Muncie, Indiana facility from January 30th to April 14th. He could not have stolen the information, done the charge card of the identity theft, because he was locked up at the time that that was applied for. The testimony that was presented at trial is that that was applied for in March, approximately 1 week after Mr. Foley was arrested. But Matt Rucka was incarcerated at that time. As a matter of fact, he got out April 14th from Muncie, and by May 21st, he's been locked up in the Branch County Jail and remains there. So he couldn't have stolen the card or the information to get the card. He couldn't have done the transfer of funds to New York, has been suggested, and he couldn't have committed the murder. And that is why the argument has been made by Mr. Schaefer that this lady's information is so relevant. When you remove Matt Rucka from the mix, we have nothing more than another person saying that she saw somebody pulling out of the end of the driveway. That's what we have. It's cumulative. Within the memorandum, there's no question there were conclusions being based that were made on erroneous assumptions and facts. No question. But the law in People v. Lester pretty much sets out from the court and for Mr. Schaefer the requirements that he needs to make in order, based on newly discovered evidence, for you to grant this motion. First, the evidence itself has to be truly newly discovered, and it's not merely its materiality that is relevant. The evidence is not merely cumulative, is the second prong. Third, the evidence is such as to render a different result probable on retrial. The fourth is that the defendant could not, without reasonable diligence, have produced it at trial. And as far as the newly discovered witness is concerned, People v. Miller indicates that an analysis of a newly discovered witness must necessarily include the plausibility of the proposed testimony and its comparison to the known body of evidence presented at trial. Your Honor, the defendant hasn't met all four of the requirements. The newly discovered evidence seems questionable at best. The evidence would be cumulative. We already heard testimony from two other people at trial who basically testified to the same information, that they saw a vehicle speeding out of the Foley driveway. There's no probability that this information is going to render a different result. As I just referred to the witnesses presented at trial, they essentially testified to the same thing. The jury had the opportunity to consider that evidence, Your Honor, and they chose not to accept the inference to be made by the information that there was someone other than Tom Foley that was culpable for this murder. And as we've indicated, we certainly question whether this witness is actually a newly discovered witness. I have no doubt that Mr. Schaefer had not had contact with her prior to the end of the trial. But defendant's FOIA requests on Matthew Rucka, it just seems rather convenient that Ms. Moore appears to the defendant's mother and makes an identification of Matt Rucka. And then you look at the testimony that was attempted to be elicited from Russ Rucka at the trial, that all inferred that the defendant knew that this witness, or somebody knew that the witness was out there prior to the onset of the jury trial. I mean, my recollection is that Mr. Schaefer went so far as to promise the jury in his opening statement that he was going to deliver a specific individual at trial. The argument made by the defendant certainly is not plausible given that Matthew Rucka was incarcerated. He could not have committed the crime. Your Honor, we believe that the defense is grabbing at straws at this point. They've been determined throughout this case to point a finger at somebody in the victim's family.